Hey, this is definitely interesting. Can somebody bring up the entrance to me to the golf course we about to start? All right. Yeah, I just called it. The phone just kept ringing. Okay.
whole 2-minute thing was clearly premature. So do I need to give you another 2 minutes when I actually get close? I mean, I'm asking, if you need to, I can delay for a moment. Silence was the loud reply. All right, Mr. Anderson, I'm Judge Lake. I'll be conducting your bond hearing and the first appearance on the charge of murder. Murder is punishable by life imprisonment or death, and as such is a capital offense. And I won't be setting bond on that charge today, although we will go through a few things. I will be determining conditions of bond on the 3 counts of attempted murder and the 4 counts of possession of weapon during a violent crime. Some general notifications. Let me address one thing right quick. As you know, you've been charged with several criminal offenses, and if found guilty, you're facing on these first 7 charges that we'll be talking about, you're facing the possibility of having to pay a fine or serve time in prison. There are other consequences such as loss of driver's license, loss of right to possess firearms and ammunition. In some cases, immigration status could be affected. Not that all that affects your case, but because you are facing that type of remedy and those type remedies, you are entitled to certain constitutional rights, such as the right to have a trial by jury, the right to be represented by counsel. Obviously, you can hire a lawyer. If you are financially unable to afford counsel, you can be screened to see if you qualify to have a lawyer appointed to represent you, and I'll have a little more to say about that in a moment. Or you can represent yourself, but self-representation can be dangerous because there may be certain defenses, objections, things that could be brought up in your behalf that you would not necessarily know to bring up, or when to bring them up, or how to bring them up. And it would be your attorney's responsibility to do that in your behalf. If you are convicted and are ordered to pay a fine, there can be arrangements made by the trial court to make a payment plan. If the charge against you is dismissed or you're found not guilty, the record of the case can be expunged. You will be given a, you will appear before the next term of the Court of General Sessions on July the 25th at 9 a.m. Your case may or may not get handled that day. And you're required under conditions of any bond that's set to continue to appear until your case is ultimately disposed of. And because of that, I don't know that it would be important in your case, but I will give you the notification that you're required to keep the court notified of your contact information, address, telephone number, and if that changes, you're required to keep the court notified of it. Any question about those rights so far? All right. In addition to those rights, I will send you a form that you can use to request a preliminary hearing before me or another magistrate for a determination to be made on whether or not there's probable cause. And this form, you or your lawyer needs to turn in within 10 days to preserve that right. I will send you a copy of an application to be screened for public defender. Whether you decide to use it or not, I'm going to include that in the information that I'll be sending you. I have an address for you of 3930A Greenwood Drive, West Columbia, South Carolina. Is that correct?
Yes, sir.
How long have you lived at that address?
Since about October last year.
Where did you live prior to that?
My grandmother's house.
And is that in West Columbia?
No, sir, it's in Gadsden.
Okay. All right. Have you ever lived outside of the state of South Carolina?
Yes, sir.
When, and tell me a little about that.
It's been multiple years ago.
Okay. Are you presently employed?
Yes, sir.
Where do you work, or where have you been working?
WM Roebuck Incorporated. We do traffic lights and commercial ITS and road signs.
Okay. All right, I'm not going to get into the merits of the case today. That will be for another time. The only determination to be made today is conditions of bond. I'll be hearing from probably, first of all, Sergeant Gilliard and/or the victim's advocate and/or victims. Sergeant Gilliard, would you care to go and to finish my sentence? And Mr. Anderson, I will hear back from you again before making a determination. Sergeant Gilliard, anything to offer?
Yes, Your Honor. If you please the court, Mr. Anderson is being charged on the warrants that you just read to him, stemming from a shooting incident that occurred on May the 13th, a Friday, close to midnight hours, where six-year-old Winston Hunter actually died from the shooting. His family was present, mother Courtney Hunter, his dad Everett Coulter, and brother Ahmad Hunter. Your Honor, we're asking that when speaking to Mr. Anderson, he actually confessed and implicated the defendants, co-defendants in the case. And we're asking that the charges of the possession of the weapon charge and also attempted murder charge be sent up to General Sessions with the murder warrants to be handled by a certain court judge.
All right. And anything from victim's advocate? They're not appearing on the screen, so. Oh, well, there we are.
Yes.
Go ahead, Ms. Robinson.
As Sergeant this case back from a shooting that took the life of a 6-year-old who was intelligent and bright, loving, and everyone left this was a senseless. We do have the victim, his mother, other present. They will be present, active in this. We are asking with the attempt and the it's up sessions with other charges.
All right, Ms. Robinson, you were breaking up a little bit. I did hear the main part of your recommendation, but I'm not sure if you would like for the victims and family members to speak. I'm not sure if they will be breaking up too. Would they care to make a statement?
Yeah, this time, save all of their comments for a later date.
Okay, all right. All right, anything further in behalf of either the state or victim's advocate concerning bond on Mr. Anderson?
Nothing from the state, Your Honor.
All right, Mr. Anderson, is there anything that you want me to take into consideration concerning bond on these first 7 charges?
It might not make a difference, Your Honor, but on the way to do such an act, I was told that if I did not act, I would be killed instead. And then after the fact, I was told once again that if I reported my vehicle stolen, I would again be shot and killed.
All right, much of that I suspect would be better handled either at the preliminary hearing or trial, but I won't prevent you from at least referencing that. All right, any other discussion of the motion? On the charge, the 3 charges of possession of weapon during violent crime, I will set bond at $10,000 cash or surety on each of those. On the charge of attempted murder, I find that bond should be denied on each of those counts, and so no bond will be granted in that regard. Now, I can't grant bond on the charge of murder, and that won't even be considered today, but I do need to give you some additional advisements. All of those advisements about attorneys, about right to trial by jury, apply to this charge as well. But I do want to at least give you one, well, I will have to acknowledge that I have given you this information, and you'll see what I mean in a moment as far as what I'll have to check off, but I'll just read it to you. The defendant has been advised that if he chooses to apply for counsel, a $40 application fee must be paid to the clerk of court located at, I can provide that information, before that application will be processed. There is an exception to that rule, and the clerk may waive that, may choose to waive that, but I'm required to acknowledge that I've given you that information. Also, the defendant understands that he has the right to apply for the services of the public defender and that he expressly waives the services of counsel by appointment of the public defender. Well, I'm advising you that that may be the case. You don't have to make that decision at this point. The defendant has been informed that he has the right to be present at trial on the charges for which he has been arrested, and that the trial will proceed in his absence should he fail to appear in court. And I'll just ask, do you acknowledge that you understand that? Okay. All right. And so, as I say, there won't be any bond consideration of that at this point. You will have the opportunity to appear before the circuit court in regard to that. Now, from this point forward, everything else will be administrative in nature. There won't be any further decision-making process, and so we can adjourn our proceedings. I will send some paperwork over to you shortly for you to acknowledge those things that we talked about. All right? We're adjourned.
Thank you.
You're welcome to collect.